ಸರ್ ತಾವು ಮ್ಯೂಟ್ ಆಗಿದ್ದೀರಾ ಸರ್?
We can start, sir. We can start.
Please, sir. Please. Thank you very much. Good evening. A warm welcome to all of you to the webinar series hosted by Advocate Association Bengaluru. We have with us today His Lordship Honorable Mr. Justice H Billappa, former Judge, High Court of Karnataka. Sir, we are both privileged and honored to have you with us today. Welcome to the webinar. With immense pleasure, now I would like to introduce our today's speaker, His Lordship Honorable Mr. Justice Hon'ble Mr. Graduated from RL Law College, Davangere, initially interned with Shri C.N. Kamath Advocate for 4 years. And later his Lordship enrolled in 1978. Lordship had joined the office of Shri P.G.C. Changappa, and for a short period, his Lordship also worked with Shri D.V. Shamanna. His Lordship had extensive practice before the Honorable High Court of Karnataka. His Lordship had worked as an additional government advocate and government advocate. His Lordship was the public prosecutor representing the Bengaluru Rural District before the Honorable Sessions Court. His Lordship also was a standing counsel for the Karnataka State Road Transport Corporation and Tamil Nadu Road Transport Corporation. Apart from advocacy, His Lordship has a flair for teaching and has served as a professor in law at SJR College of Law, Sheshadripuram College, Vivekananda Law College. Later, His Lordship elevated as a judge of the Honorable High Court of Karnataka in the year 2003. After a rich tenure of more than 1.5 decades as a judge, His Lordship retired in the year 2016. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir. Sir, you are muted. I'll unmute you.
Yes. Hello, sir.
Yes, sir.
Yes. At the outset, I would like to sincerely thank all the office bearers of the Bangalore Advocates Association and all the members of the board and also all the participants in this webinar. It's truly a great privilege to address the members of the board on a topic like this. I am extremely happy because that it is in Bangalore Advocates Association everything happened for me. I practiced there, a lot of friends were there, and then I became a judge. I served in law colleges. All these things happened when I was practicing as a lawyer at Bangalore Advocates Association. And I am extremely happy that I am invited to talk on a very important topic, that is burden of proof. We know that the cardinal principles of Evidence Act are that the best evidence must be produced, hearsay evidence must be excluded, and the evidence which is relevant to the case, in the sense which relates to the facts in issue and relevant to the case, only must be adduced. They are the cardinal principles of the Evidence Act. And a fact can be proved in the court of law by adducing oral evidence, documentary evidence, confessions, admissions. Of course, sometimes inferences are also drawn by presumptions. That is the way the facts are proved before the court. So unless facts are proved before the court court cannot make a decision. Therefore, you can just see the cardinal principles that the best evidence must be produced, hearsay evidence must be excluded, and evidence relevant to the case must be produced. How easy it is if we understand this properly. The best evidence is before the court, hearsay evidence is excluded, and only the evidence that is relevant to the case is presented to the court. How easy it is for the court to make a decision or for the lawyers to argue the case, because only all that is required is there before the court. Therefore, it's relevant to know this important topic, the burden of proof. Before venturing into the provisions from section 101 to 114, three expressions, particularly a fact proved, disproved, and not proved. All these things have consequences in law. We must know that what a fact proved means, what is disproved means, what is not proved. Everything proved, it has some consequence. Not proved, it has some consequence. Disproved, it also has some consequences. Now, these terms, they are defined in the Evidence Act. A fact is proved, we say that a fact is proved when the court, after considering the matters before it, believes that the fact exists. This is very, very important. And the second thing is, or the court considers that a prudent man would proceed in the circumstances of the case that the fact exists. Two things, two criteria are there in this. The first one is the court considering the matter before it. The word used is matters. It is not just evidence. Matters means it may be oral evidence, it may be documentary evidence, it may be confessions, it may be admissions, or it may be the material objects that are produced, or it may be the demeanor of the witnesses in the course of trial. All these things the court should consider before rendering a finding on the facts in issue. That becomes, if the court, after considering the matters before it, means all considering all these things, the evidence before this court, the demeanor, the circumstances of the case, how the trial went on, considering all these things, if the court believes that the facts exist, then we say a fact is proved. The second thing is, supposing, where the case relies on probabilities of the case. The next thing is, the court considers that a prudent man in the circumstances of the case would proceed with the supposition that the fact exists. That's another thing. The next thing is how a prudent man assess the evidence or the material on record. If he proceeds with the supposition that the fact exists, then also the fact is proved. So therefore, to say that a fact is proved, two things are essential. One, the court considering the matters before it believes that the fact exists, or a prudent man would proceed that the fact exists. These are the two things. Similarly, a fact disproved means the court, after considering the matters before it, believes that the fact does not exist, or considers that it is so probable that prudent man in the circumstances of the case would proceed with the supposition the fact does not exist. That is what is disproved. Means either proving a fact or not proving a fact is a positive thing. That means either the fact exists, somebody shows that the fact exists, or somebody shows the fact does not exist. Not proved is when the case is neither proved, or a fact is neither proved nor disproved, then we say a fact is not proved. There are the cases. Look at the consequences. What happens? Supposing all that is asserted or affirmed by the plaintiff is established before the court. The court says, yes, the plaintiff has proved his case then the consequence is it results in decree. That means the plaintiff succeeds in the case. If it is disproved, say, then the plaintiff loses the case because the facts which he asserts are disproved by positive evidence disproved. So in a criminal case, for example, say it is, the court cannot say from the material and record whether it is proved or not proved. They are the cases of not proved, then it results in an acquittal. Supposing if the case alleged by the prosecution is not proved, it's neither proved nor disproved, means the court is not in a position to make any decision to say positively whether the accused has committed a crime or not, then it results in an acquittal. If it is a civil case, it should necessarily, because the court is not in a position to record any positive finding for positive evidence, the court can say that the fact is not proved, therefore it may go against the plaintiff or the party concerned. Therefore, these three things, that a fact must be proved, and a fact disproved, and a fact not proved, they have certain consequences in law. So with this background, let's now see that what is the burden of proof mean. When a party comes before the court, section 101 to 114, they deal with the burden of proof in various circumstances. Now, section 101 of Evidence Act deals with burden of proof. So when a party wants a judgment in his favor, he wants the court to give a judgment in his favor on the basis of the facts that are asserted by him. To succeed in the case, he is bound to prove those facts. A person who comes before the court asserting certain facts, if he wants the court to give judgment in his favor, he must necessarily prove those facts. Unless those facts are proved by the party on whom the burden lies, he cannot succeed in the case. Therefore, we say a burden is on a particular party when the party is bound to prove the fact. That's very, very important. So a party who wants judgment in his favor as regards right or liability must necessarily prove the facts asserted by him. If he is bound to prove to succeed in the case, then we say the burden is on that person. The burden of proof is on that person who asserts certain facts and then wants judgment is in favor. And he must prove those facts to take decision in his favor. That's a very, very important thing. So the burden is on that party. This will never change. This burden based on pleadings and law will never change. It is constant throughout the proceedings. This will never change at all. But look at section 102 of the Evidence Act. Not who should lead the evidence, who should introduce the evidence in a suit. So where in a suit or proceedings, who should lead the evidence is the question. The party who fails, if none of the parties adduce any evidence, is the party who should lead evidence in a case. So section 101 speaks of burden of proof. Section 102 those speaks of burden of proof in the sense of introducing evidence. So burden of proof in two senses. One, in the sense based on pleadings and evidence on record, based on pleadings and law, and in the second sense, in the sense of introducing the evidence. Insofar as the burden of proof based on pleadings and evidence is concerned, it never changes. It is constant throughout the trial. The burden that is placed, it remains, and the party on whom the burden lies, he must prove the fact to if he wants to succeed in the case. But insofar as the second thing, section 102 is concerned, leading evidence is concerned, if one party adduces some evidence, then the onus starts shifting. So this keeps on changing. It's still like a balance. It keeps on changing from if one party leads evidence, then the owner shifts on the other party to lead counter evidence or rebuttal evidence. So in the sense of introducing evidence, it always keeps on changing. That is called as onus probandi or onus of proof. So in the trial, in the course of trial or proceedings, the onus of proofs keeps on changing, but insofar as the burden based on pleadings and evidence is concerned, it never changes, it never shifts, it is constant throughout the trial. That we must know that. There may be certain occasions when we need to a particular fact. Now section 101 speaks of all facts asserted, but there are certain circumstances when a particular party wants the court to believe a particular thing or a fact, then the burden is on that person to show that fact exists. For example, say in a criminal case, the accused take the defense of alibi that he was elsewhere at the time of commission of the crime. He was not at the place of occurrence at all. Then the burden that he was elsewhere, it is to his knowledge, therefore the burden lies on that. He wants the court to believe. If court believes that statement that he was not at the place of occurrence at the time when the incident occurred, he could not have been the author of the crime, then it results in his acquittal. No criminal liability can be fastened on that man. Therefore, the burden of proving that fact which is known to him is on him. Such facts like that. So that person, insofar as proving of a particular fact is concerned, it is on that person who wants the court to believe the existence of that fact, unless the law says that somebody else should prove. If it is not fixed by law, the fact which is within the knowledge, or a person wants a particular fact to be believed by the court, he must prove that fact. Now there are certain circumstances when we need to prove certain preliminary facts before adducing evidence on the relevant fact. Well, for example, say if you want in a criminal case, somebody wants to prove a dying declaration, say. So now, before a person or the prosecution which wants to introduce the evidence regarding dying declaration, unless it proves that the person who has made the declaration or statement has died, it cannot prove the dying declaration at all. Therefore, there are certain circumstances when a fact needs to be proved before adducing evidence on the relevant fact. So then, in such circumstances, the party who wants to lead the evidence, the burden is on that person to prove that particular fact. In a dying declaration, as I told you, that before proving the dying declaration, it must be shown that the person who has made this statement or declaration is no more. Unless that fact is established first, you can't prove the dying declaration. Similarly, we have seen in many cases where secondary evidence needs to be adduced. So in such a circumstance, so the basic principle of cardinal principle of Evidence Act is that best evidence should be produced. Primary evidence is always preferred by all the courts. So now suppose you are not able to produce primary evidence, you want to adduce secondary evidence, then what is to be done? So if you want to adduce secondary evidence, of course it is permissible in law, but you must show, say for example, a man wants to adduce secondary evidence regarding a sale transaction. The original sale deed should be produced. That is the principle. The primary evidence is the original sale deed. Suppose he is not able, it is destroyed, it is lost, it is burnt, or it is not easily available, or it is in the custody of the other party. In those circumstances, the person who wants to adduce secondary evidence must first prove why he is not able to produce the primary evidence. Unless that fact is established, he can say, sir, the sale deed is lost. The importance of this is, when once he says, gives reason for that why he is not able to produce the primary evidence, later on he can't turn back, oh no, now it is available. He can't do that. That is the purpose of that. Therefore, the party who wants to lead secondary evidence must first show to the court why he is not able to produce the primary evidence. Only then court can permit himself. So these are the circumstances where a particular party wants to lead evidence regarding relevant fact, needs to prove certain preliminary facts before adducing evidence on relevant fact. In criminal cases, section 105 speaks of general exceptions, the defenses that are taken. We know that the burden is always on the prosecution. In all criminal cases, the burden to prove, establish the crime is always on the prosecution. Prosecution must prove that. The accused can enter his defense after the prosecution adduces an evidence. Supposing the court feels that the evidence adduced by the prosecution is insufficient to convict the accused, there is no point even in calling upon the accused to adduce the evidence. See, the court can, at that stage itself, before calling upon the accused to enter his defense, the court can say there is no proof, enough evidence on record to convict the man. It can acquit at that stage itself. If the court feels that there is a prima facie case, the prosecution has led evidence, then it can call upon the accused to enter his defense. So now how accused can, he wants to plead, there is a prima facie case, say accused wants to take, he says his case falls within general exceptions. So there are general exceptions, there are special exceptions, there are provisos, there are defenses available elsewhere. So now if the accused wants to say that his case falls within general exceptions, then the burden is on the accused. Though the burden of establishing the case, prosecution's case, is on the prosecution, when once it discharges its burden, it is for the accused to defend it. Then he can enter his defense, and that is by different ways. Accused can examine himself, possible, or he can examine witnesses in his support, or he can rely upon the cross-examination. He can elicit from the mouth of the witnesses of the prosecution in support of his defense. He can do that also. So he can either plead, yes, this is my defense. So when once accused wants to defend the crime, not general denial. If it is general denial, I am not responsible, I am not the author of the crime, it all depends upon the prosecution's evidence, quality of the prosecution's evidence, and if the court believes or accepts the version of the prosecution, it can convict. But when once it takes a specific stand, like general exceptions or special exceptions or provisos, he wants to claim the benefit of that, he must prove the burden of establishing that the case of the accused falls under any general exceptions, maybe mistake of fact or mistake of law or consent as a defense or an accidental act, or that a person is of unsound mind, right a private defense. All these things, they are the general exceptions. He must defend the crime there. He must say, sir, it happened. For example, take culpable homicide amounting to murder and culpable homicide not amounting to murder. If the accused want to say that the incident has occurred under sudden and grave provocation, the burden is on him to show from the circumstances. He can lead evidence also, there is no doubt about that, and he need not examine the witnesses. From the mouth of the prosecution witnesses itself, he can elicit answers in support of his defense and tell the court, this is the thing, these are the circumstances in which the incident has occurred. It is under sudden and grave provocation, therefore I fall within the exception. Therefore this culpable homicide does not amount to murder, less than that punishment can be reduced. Or say an accused wants to plead that he was a person of unsound mind, he was suffering from insanity, he claims insanity as a defense. Then the burden is on him to show that at the time when the act was committed, that he was not capable of judging things, he was not capable of making whether he is committing any crime, he is committing any wrong or not. He was not capable of knowing that. He was a person of unsound mind. That is section 84 of the Indian Penal Code. If he wants to establish the defense of unsound mind, the burden is on the accused to show that he falls within those general exceptions and he can claim the benefit. So intoxication, if he claims as a defense, he must show that the nature, how he was affected by that, or it was not voluntary intoxication. Law says when intoxication can be a defense, he can plead intoxication as a defense. If he wants to claim the benefit of the intoxication as a defense, he must show to the court the burden is on that man. Similarly, right of private defense is one of the general exceptions. If he wants to show that to defend his body or somebody's body, to defend his property or somebody's property, he has committed the crime and he is entitled for the benefit of right of private defense, you are justified in doing that act, then it is for the accused to show that he falls within the general exceptions. So when once the defense he claims, the accused wants to claim the benefit of these special, for example, defamation, you say section 499 of the Indian Penal Code, the exceptions are provided there itself. There are any number of exceptions when it does not amount to defamation. If he is justified in doing that, in public interest he is doing that. So all those exceptions which are there, which are special exceptions in the provision itself, if anybody wants to claim the benefit of that as a defense, he must establish, the burden is on the accused to show that he falls within the exception. So section 105 of the Evidence Act says that if the accused in a criminal case wants to claim the benefit of general exceptions or special exceptions or provisos, so all that defense, the burden is on the accused to establish that his case falls within general exceptions or the benefit that is available under law. That is the burden. Now there are certain circumstances when the fact is exclusively within the knowledge of a person. Who should prove that? Nobody else knows that. So irrespective of whether he is a plaintiff or defendant, whoever he is, if a fact is exclusively within the knowledge, especially within the knowledge of a person, that person must prove that fact. For example, in maintenance cases, we see in it's our experience in any number of cases, husband never discloses his income at all. Therefore, the wife claims based on some guesswork. All right, maybe my husband is working like this. He may be earning so much. Only on guesswork. Approximately, she mentions that. Now, the fact how much he is getting every month. See, husband is a salaried person, say, or the income, what he as a businessman, what he is getting, really husband knows. That is a fact which is exclusively within the knowledge of the husband and none else. Then who should prove? The Act says, Evidence Act says, that in such circumstances where a particular fact is exclusively within the knowledge of an individual, it is that person, husband must prove that. Otherwise, if he does not prove, it is failing to lead the evidence regarding that, then the guesswork, the wife claims case needs to be accepted. Therefore, when a fact is exclusively within the knowledge of a person, it is that person who should prove it. See, in one criminal case, it was the driver was from a different place. He was driving the vehicle, and the vehicle met with an accident. There were two drivers because it was a very long journey. Therefore, there were two drivers in the. This driver said that I am not responsible for sir. The defense was, I am not responsible for this sir. The other driver was driving the vehicle at the time when the incident occurred. That was his specific defense, but did not lead any evidence at all. Now, you please see here, the fact that who was driving at that relevant point of time and the incident is not denying. The accident has occurred, he admits, but what he denies is, I am not responsible for the accident, somebody else is responsible for the accident. This is a fact exclusively within the knowledge of somebody else. That person must prove, show to the court that actually he was driving and not this man. If he fails to do that, discharge that burden, then court can say that you have failed to do that, and the version of the prosecution can be accepted. So there are certain circumstances like this where certain, say a person has done a particular act with particular intention, say in bona fide or for good reasons he has done, but actually what appears from the conduct and the circumstances of the case is he has committed something wrong, but it is for him that knowledge why he did that particular act, with what intention he did that act, is exclusively within that knowledge. In those circumstances, that man who possesses the knowledge of the fact, he must prove that fact. The burden to establish how he intended to do that is on that person. He must establish those facts. Sections 100 and 708 deal with presumptions. That we know the question before the court is saying whether a person is alive or dead. Now there are two aspects here. One, supposing a person is shown to be alive within 30 years. A person is shown to be alive within 30 years. Law presumes that he is still alive. If a person is shown to be alive within 30 years, law presumes he is still alive. But the exception under the 8, it provides that any person, supposing near and dear ones, kith and kins, they every day hear of a person for continuously for a period of 7 years, if that man is not heard of by those who could have naturally heard of him, who could have talked to him, he is not seen by them, he is not heard of by them, then the burden shifts on the person. Then the law presumes that the person is no more. If continuously for a period of 7 years, if a person is not heard of or not known, his whereabouts are not known by those persons who could have naturally heard of about him, then law presumes he is no more, and the burden shifts on the person who says that no, he is dead. So these two provisions, there are two presumptions here. One, a person shown to be alive within 30 years, it is presumed that he is still alive. But if by way of rebuttal, if it is shown that man is not heard of by the kith and kin, nearest relatives, he is not heard of for a period of 7 years, then the onus shifts on the other man to show that he is still alive. Whoever affirms that he is still alive, he must prove that. Here, there is no presumption with regard to the date of death, when actually he died. Court cannot presume he died on this particular date in this particular month. There is nothing like that. Law says if a man is not heard of for a period of 7 years, so it can be presumed that he is no more unless it is shown that he is still alive. That is the principle there. The date of death or the year of death is not presumed by the court. And the latest, at the most, we can say, when the suit is presented to the court, we can say that is the time we can count for to count the period of 7 years. We can take the date of filing the suit before the court. We can take those 7 years. Otherwise, there is no presumption in law regarding the date of death or when actually the person died. But there is presumption that man is no more. That is all the presumption that is available under section 107 and 108. And now there are certain relationships, say partners, tenant, landlord and tenant, principal and agent. These relationships are there. There are certain relationships. They exist and then they behave. The partners show to the whole world that they are partners in a particular firm, or the landlord and tenant, they have represented to everybody that they are landlord and tenant. Similarly, agent, principal and agent, they have shown to the world they are principal and somebody is the agent. Continuously, they have made the people to believe that they are continuing with that relationship. When once it is shown that those people represented and shown to the world that they had that relationship, the presumption is they are still continuing in the same relationship. If anybody says, no, no, I am no more a partner there, no, no, I am not a tenant there, or no, I am not the agent of that man, or the principal says that I have terminated his agency, all these things, if somebody asserts contrary to that, then the burden is on that man to show that we are not continuing, the relationship has come to an end. So we are no more the partners, or we are no more the landlord and tenant, we are no more the principal and agent. The burden is on that person to show that they have ceased to be in that relationship. That is one more presumption available. And sometimes regarding this possession also, now suppose somebody is in possession, is shown to be in possession. Anybody, a person, if it is shown that a person is in possession of the property, if anybody denies that he is the owner of the property, the burden is on that person to show that the person who is in possession is not the owner. So in many capacities, many relationships, we can be in possession of the property. As a licensee we can be there, as a tenant we can be possession, and sometimes unauthorized occupation can also be there, adverse possessions may be there. Different ways a man can be in possession of the property. But if it is shown that somebody is in possession of the property, so if somebody denies the man who is in possession is not the owner, the burden of proving that the person who is in possession is not actually the owner of the property. The person who says that he is not the owner, or in his capacity as a owner he is in possession, that person must show to the court that he is not the owner, though he is in possession of the property. The presumption is a man who is shown to be in possession is the owner. But anybody pleads or says that he is not the owner, as a owner he is not in possession, that person must prove that fact, that he is not the owner. And then there are certain other transactions which take place between persons in fiduciary relationships, say father and son, and father are transactions which take place. A person who has control, who can dominate the mind, who can dominate the will, who can have control over the other person. In such relationships, if some transactions take place, say an attorney, a lawyer and a client relationship is there. The lawyer purchases the property of his own client. Now you see the relationship between the lawyer and the client. The lawyer can dominate. Supposing the client moves the court and says that this sale transaction is not a genuine transaction and I was dominated by my lawyer, and some undue influence or coercion has taken place, the sale deed that is executed is not a voluntary act. If that's there, then in such cases where the transaction has taken place and one person is in a position to dominate the other man, then the burden of showing that the transaction is done in good faith. Now, the burden of showing that the transaction is in good faith is on the person who can control, who can dominate. Say between a father and son, some transaction has taken place between father and son. Father can dominate the son, and transaction has taken place. Then if the son moves the court saying that this is not a genuine transaction, the burden that the transaction was made in good faith is always on the person who can dominate or who can control that person. So this can happen. Say these ladies who practice, these Pardanishan ladies are there, illiterate persons with whom the transactions have taken place. It can be there in many ways. This can occur. The test is where a person, the relationship between the persons is such that one person can dominate the other man. In such cases where the transaction has taken place between those two persons, then it is for that person to show, the person who can dominate the will, it is for that person to show that the transaction was made in good faith and there is nothing as early as either fraud, coercion or undue influence There is nothing like that. It is for them to show that. That's the thing. Section 112 of the Evidence Act is really a very important provision. Is this there? This is about the presumption regarding legitimacy of the children. See, a valid marriage subsists during the continuance of the valid marriage between a husband and any wife and any person during the subsistence of the marriage, or within 280 days from the dissolution of the marriage. Two things are there. One thing is that subsisting marriage, continuance of the marriage. Second thing is where dissolution has occurred. Dissolution has occurred within 280 days. A child is born to them. A child is born either during the subsistence of the marriage or within 280 days after the dissolution of the marriage. The marriage, within marriage, then the presumption is the child that is born to them is a legitimate child. This is the presumption. Law presumes that if a child is born during the subsistence of the valid marriage or within 280 days from the dissolution of the marriage, law presumes that child is a legitimate child. It is the conclusive proof. The language is, there are only few sections in the Evidence Act which uses this expression conclusive proof. That is the conclusive proof that the child is a legitimate child. Then this can be defended? Say a person may be impotent, or he had no access. How it can be proved? So this action says there only one way to proving is non-access. If somebody wants to claim that the child is not the legitimate child or the child is not born to him, he should prove that there was no access when the child could have been begotten. This is the thing. That is the section 112. It gives, see, law does not want to bastardize some persons. Therefore, law presumes that where there is a subsisting marriage or within particular period after dissolution, if a child is born, it is presumed it is the legitimate child of those husband and wife. And the husband can say, only show that he had no access to the lady at all when the child could have been begotten. So now there was like this, whether they can be, all tests, scientific tests are available these days, whether we can continue with this presumption. There is one judgment of the Supreme Court that is like all these days, even in criminal cases also, whether he can be subjected to DNA tests or the tests like that, there can be no testimonial compulsion. It can amount to extracting evidence against the accused, violates Article 20 or 21. That was the thinking that was there. Supposing the husband wants to prove scientifically, by scientific evidence, that though he had access but the child is not born to him, then what is to be done? The section says there are only option. The only option for you is to prove non-access. There is no other way. But anyway, in this judgment, this is reported in AR 2014 SC, page 932. This was Nandalal Vasudev Bradwick versus Lata Nandalalan. In this case, there was where there is a conflict between conclusive proof and scientific evidence permissible. Now the court has shown, there are some cases like this where the court now is tending towards, if there is the whole world is accepting that if it is scientifically proved that the child is not born to him by DNA test like that, that should be accepted. That's the thinking now. But the section as it is, even now it shows that section 112, even today, non-access is what is permissible in law. But this judgment says that needs to be accepted if the whole world accepts this scientific advancement, and there is nothing wrong in accepting that that is how it should prevail. This scientific opinion or the evidence should prevail over this presumption of law. That is how that view is taken. But still, there are conflicting views, thinking like this, also thinking like that. It is not very certain now, and there is no change in the provision. That may be changed where it is proved. This can also be permitted, that if it is scientifically proved that the child is not the legitimate child of that man, then that's a different thing. But as of now, this is what is there regarding 112. 113 is about cessation of territory. That was during British period. 114 is also very important sections. As I told you, now there are different ways of proving in a proceedings. So it can be by oral evidence you can prove a fact, by documentary evidence you can prove a fact, by confessions you can prove a fact, by admissions. There are certain things, circumstances when by presumption also inferences can be drawn. This 114, to use it, it requires experience, lot of experience, understanding of life, men and matter, law, everything should be understood to draw inferences. This provides, 114 provides that the court may presume that having regard to so many things, natural events and how people conduct human conduct and how people behave in their private businesses, in public acts, how they behave, depending upon that, court can also presume certain. But there must be foundation, not blindly certain facts can be presumed. Some illustrations are given. For example, a stolen property, immediately it is found in possession, immediately after theft has occurred, and immediately it is the stolen property is found in possession. Two presumptions are possible. Either this man has committed the theft and is in possession of the property, or he has received the stolen property. These are the two possible presumptions in a circumstance like that. If a man is found in possession of stolen property immediately, look at that, immediately after theft, the two presumptions available is that either he has received it, a stolen property, or he himself has committed theft. These are the two possible presumptions that can. He can have explanation. He is innocent, and somebody who had just threw the property and then ran away from the place, and he picked it up and he is in possession. He can explain it in different ways. How he explains it is fine. But court can draw presumptions in such circumstances, like regularly a notice is sent, say, by registered post, and it is returned with an endorsement refused. So court can presume that because that is the duty of the postman to serve the notice, he has taken there, it is handed over. Then if somebody disputes this, or the person, the addressee disputes this, it is for him to show that it was never tendered to him. But this is only rebuttable presumption. Whether it is may be presumed or shall be presumed, there are certain provisions where it may be presumed, there are certain provisions where it shall be, and the conclusive proof. Insofar as conclusive proof is concerned, no evidence. Court can draw presumption and then that is it. But no evidence can. But insofar as may be presumed circumstances or shall be presumed circumstances are concerned, rebuttal is always possible. Evidence can be adduced contrary to that. If it is shown, court can accept that, but court can draw a presumption. Natural course, for example, we know that a river is flowing, and these days we are hearing floods. Supposing Kaveri river is flowing in a particular direction in a particular place, and somebody leaves evidence, but due to floods and other things, it has changed its course. But court can presume that Kaveri used to flow in a particular way. Natural events as there. Sun rises in the east, sets in the west, never in the north and south. This is our understanding. So these are all natural events. Court can presume that. Court can presume that. And then anybody who contradicts this or who disputes this, he must adduce evidence to show, to rebut this and show that no, that is not the correct thinking. Well, I said recently we are seeing here, because of the floods, the courses have changed. And then if somebody comes and says, "No, sir, water was flowing," we can't say, "No, no, no, that is not the course I say." We can't say. It can happen, it is possible. But having regard to the natural course of events, men and matters, their conduct, how people behave. For example, judicial acts, say, official acts, they are presumed to be done in the normal way, as required, as expected of them. It is presumed. But if somebody disputes this, no, that has not happened that way, it has happened in a different way, they can always lead evidence and show that that has not happened in any way. So section 114 of the Evidence Act deals with presumptions when court can draw inferences based on its experience and having regard to these things: natural course of events, how they occur, how people conduct, how people behave in a given circumstance, depending upon that, and also relating to that particular case, having regard to the circumstances of that case, court can presume certain facts, but that is a rebuttable presumption. Contrary can be always proved, that is permissible. Now, next, other 2-3 presumptions are very important. 113A, 13B, they are very important. Now, abatement of suicide, there is a presumption now in law. By way of amendment, that section is introduced now. A suicide occurs, say, within 7 years, a lady commits a suicide, and if it is shown that she was subjected to cruelty by her husband or relatives, then having regard to, this is very important, all the circumstances, court must be very cautious in drawing presumptions under this provision, having regard to the other circumstances of the case. If it is shown to the court that a lady who has committed suicide within 7 years from the time of marriage, if it is shown that she was subjected to cruelty by her husband or relatives, and having regard to the other circumstances of the case, court can presume that they have abated this crime. Court can. This is the presumption now available. And the next thing is, in case of dowry death, that is a very, very cruel act now. There also, dowry death is like almost like a culpable homicide now. If a lady, their self-infliction is there, say maybe death may be due to hanging, burning, for so many reasons. If death happens, if it is shown, this is very, very important, because soon before the death, this is the word, but soon, how soon? Is it few hours, is it few days, is it few months? That is not there. Supposing if a lady dies an unnatural death, if a woman dies an unnatural death, then the person, if the death, soon before the death, she was subjected to cruelty, not all kinds of cruelty, cruelty relatable to, in connection with demand of dowry. Dowry death means the demand must be in connection with, or dowry demand. If the lady is subjected to cruelty soon before her death, if she is subjected to cruelty demanding or in connection with the demand of dowry, then it is presumed that person is responsible for the death of that lady. Law presumes now that court shall presume that, and it is a rebuttable thing, and they can show the but now court can presume that if there is evidence to show that the lady was subjected to cruelty, but soon before death, and there are various views that it may be few days, immediately the cruelty, infliction of cruelty occurs now, within few hours the lady is no more, and it is relatable to that. So if it is relatable to the demand of dowry, or the cruelty inflicted relates to the demand of dowry, or in connection with the dowry, then the presumption is that person has caused the dowry death, and punishment follows, and it is for him to show, no, that has nothing to do with this, it is for him to show. That is another presumption. Now there is one more presumption, 114A. This is very, very important for all those who conduct criminal cases particularly. All these days we were saying that to prove consent, where the rape incident of rape occurred, what is the how it occurred, what is the place, all these things were there. Now 114A presumes now, particularly subsection 2 of section 376 IPC, A, B, C, D, there are several clauses there by the authorities, hospitals, in public places where the persons are in charge of, in control of that, and maybe orphanages or some organizations like that. There, if the sexual act is proved, this is very, very important. If the sexual act is proved and the lady, the victim of rape, comes and deposes before the court, I was not a consenting party, I did not consent, then court shall presume that the act has occurred without the consent of the lady. So all these things, Justice Krishna called this as a fossil formula, that where the incident occurred, how the incident occurs, they were subject to that. What is the character, antecedents of this lady was. Now, whether she was leading a good life, chaste life, or she was in prostitute, all these things are not there now. Maybe she is a lady of bad character, but whether this event is with her consent or without her consent is what matters. Not that how many cases in the past, how she was doing, all these things are totally irrelevant now. Injuries on the body, prove these and these, all these things are gone now. All that is required is she must come and depose before the court saying that no, I was not a consenting party this at all, and the incident has occurred without my consent, whether there may not be a slightest injury at all. So nobody can deal with somebody's body without their consent by violence. You can't do that at all. So therefore, it is whether the injuries or other circumstances, all this is that is not required now. If the lady deposes, law says it shall be presumed, but the sexual act must be proved. It must be proved by convincing evidence that the incident has occurred, sexual act has taken place. Then the lady deposes, no, I was not a consenting party for that. Then court shall presume that she had not consented for the event. That is another presumption. And there is also one change there, that you can't put questions now like that. What is the history, the background, where it has happened, what were your past? No questions can be allowed by the court even for such things now. Therefore, proving of the sexual act, whether it with consent or without consent, if the lady deposes, presume that there was no consent. That is the law as of now. And broadly, these are the things regarding burden of proof, the person. So we know that insofar as civil and criminal cases, the standard of proof is also there. It's beyond reasonable doubt, and many of us confuse what really this principle of reasonable doubt means. Is not beyond shadow of doubt or anything like that. It must be capable of explaining. Just I give you one example I can give. Normally, say 3 witnesses and I am deposed before the court in an assault case. A witness says, sir, I saw he assaulted him, he dealt 6 blows. And B, another witness comes and says, sir, I saw the incident, he dealt 10 blows. Another person comes, C, and he deposes before the court, I saw the incident, sir, he dealt 3 blows. Now the trying judge can now say, he has 2 options now. This witness, one says 3 blows, one says 6 blows, one says 8 blows. This can be appreciated, this evidence of the eyewitnesses occurrence can be appreciated in 2 ways. All these eyewitnesses are inconsistent, I don't believe them, I acquit them. That's one way. Or a judge, there is no doubt that all the 3 are saying the incident has occurred, all the 3 are saying that he assaulted, we have seen him accused of assaulting them. The only thing is it is between 3 to 8 blows. Therefore, the blows that are given are between 3 to 8. Therefore, the incident is proved, he can convict the man at all. Therefore, this benefit of giving benefit of doubt is not a doubt of a vacillating mind. or a judge who wants some fine some way, all right, let us acquit this man easy way, don't agree and then acquit her. That's not the thing. The doubt which is capable of being explained, reasonable doubt, it must have a basis, foundation, why I doubt particular thing. Only then, say for example, the in the FIR, there are no eyewitnesses at all. There are no eyewitnesses are mentioned. But in the course of a trial, two witnesses are shown to be eyewitnesses and they are examined. That is a serious omission, because if really the incident has occurred the way prosecution is there, this omission, serious omission could not have happened, or there is a conflict between the weapon used by, as the eyewitnesses are deposing, or the medical evidence, serious conflict. Doctor opines that this with this instrument such kind of injuries cannot be caused. There are the cases where the doubt is capable of being explained, not because I doubt, I fear conviction, or do something, or where my thinking is very vacillating, or I find some easy way of acquitting. That is not the reasonable doubt at all. Therefore, in all criminal cases, the benefit of doubt means reasonable doubt. It must be capable of giving positive answers. Why I doubt this, and if it is acceptable, that is a proper way of looking at that. The standard of proof is really high. That means it must convince the court that the incident has occurred or the allegations are proved by the prosecution. Insofar as civil cases, we know that it is preponderance of probabilities and a prudent man. Two things are given in the what is proved is there. That means judge believes there is, so the burden of proof, where there is overwhelming evidence, say plenty of evidence, both the plaintiff also has produced enough evidence, defendant has also evidence, burden of proof has no role there to play at all, because there is enough evidence to answer all issues. There is sufficient evidence before the court. When there is overwhelming evidence, this will go to the background, this burden of proof. But when the evidence is evenly balanced, it is very difficult to say. Then the burden of who should prove this becomes very, very relevant. So when the evidence is evenly balanced, this burden of proof becomes very, very relevant and significant. But if there is overwhelming evidence, there is no difficulty at all. Court has plenty of evidence before it, it can appreciate and answer the issues and record its findings. But where there is no evidence or evenly balanced, then this burden of proof becomes relevant. Who should have introduced the evidence? For example, let's say a person has sued on the basis of a promissory note. Say the defendant says, I have executed the promissory note, sir, but I have repaid the money. Look at that. Now who should introduce the evidence? So the plaintiff's case is admitted by that. Plaintiff's case is admitted by the defendant. He says, I have executed, but I have repaid the money. Now section 102 comes into place. The burden, no doubt, is on the plaintiff, because of the admission made by the defendant that he discharges his burden. Then who should introduce the evidence? In a suit or proceeding, the party who is going to fail, if none of the parties adduce evidence, should introduce the evidence. Therefore, where the defendant admits and pleads additional facts, then the burden is on them to plead. If he pleads discharge, the burden is on that man. Therefore, these pleadings, based on that, we can classify them into three categories. Say where denial, general denial, government, Sintara 2, 3, 4, 5, denied, including address also, everything is denied. That is called pleadings by traversal, where the plaintiff pleads something and the pleadings are by traversal, general denial. Then the burden will not shift. The entire burden of proving the case is on the plaintiff, where the pleadings are by traversal. Where the pleadings are by confession and avoidance. This is another way, where it says, Mr. X, the plaintiff is the owner of the property, no doubt, sir, but I have been in possession continuously, uninterruptedly for a period of 12 years. I have perfected more than 12 years. I have perfected my title by adverse possession. Here, the defendant admits the case of the plaintiff but pleads additional facts. In such cases where the nature of pleadings by confession and avoidance, he accepts the case, he confesses what plaintiff says is correct, but pleads additional facts in support of his case, then the burden of introducing the evidence is on the defendant who says he has perfected his title by adverse possession. That possession, proving adverse possession is on the defendant who pleads that. That is the thing. The next one is questions of law or points in law. That is another thing that depends upon whether it is a mixed question of law and facts or exclusively purely law. If it is purely law, either of the parties can argue, show to the court the provisions of law and say that this helps me or not. Either of the parties can rely upon that. But if it is a mixed question of law, say a promissory note, the suit is filed after 4 years, but there is the plaintiff pleads there is an endorsement and therefore the limitation has continued, it stands renewed, and then files a suit in the 4th year, but pleads certain facts. There it is a mixed question whether the suit is within time or not. It is a mixed question of law. Then he should lead evidence in support of it. Similarly, the defendant says that I have received notice, no doubt sir, I have received notice as a tenant, but it is not in accordance with law, or without issuing notice suit is filed. In such cases, the burden is on the defendant to show depending upon the circumstances. So the pleadings like this, if where there is general denial, the burden will never shift. It is always on the party who comes to the court who wants judgment is in favor, he should do that. Where the pleading is by confession and avoidance, then the burden of introducing the evidence is on the other side. When once he introduces the evidence, the owner shifts, it goes on like that throughout the trial, and questions of law also there. So that is the burden of proof. And if anybody asks some question, I think if we are trying, let's interact for some time.
Thank you so much, sir. Presentation. Information now we will go on to the session, sir. Sir, you're muted. I have given you the option of unmute. Sir, I have given you the option of unmute. Kindly, could you please unmute yourself?
Yes.
To begin with, sir, we'll start with Gita. Yes, sir. Can I quickly pose a question?
Yes.
Sir, good evening, Justice Billappa.
Sir, good evening, sir. Good evening.
ಚೆನ್ನಾಗಿದ್ದೀರಾ?
ಚೆನ್ನಾಗಿದ್ದೀನಿ.
Wonderful. Yes, most of your presentation was on the criminal side. In the end, you have taken to the civil. I have a question on the civil side. There's a disturbance, Trivikram.
Your voice is not
Clear. It's not clear. It's not clear. It's not clear. Voice is not clear.
What we can do is, after a while, I will switch over to now go on with Mr. Nitin DN, who has a question. Yes, Mr. Nitin, I have unmuted you.
Hello. Hello. Good evening, sir.
Yeah, good evening, sir. Good evening.
You're a wonderful.
Please, sir.
Yes, sir. Sir, my question is, sir. Sir, in here evidence, some admission comes. Whether that admission can use for to proving the burden of proof?
No idea. I am not getting, sir, the question properly. I am not getting the question properly.
Sir,
Some voice disturbance is there.
can audible, sir? I'm audible, sir.
Yes.
Yeah, sir.
Yes.
In here, suppose some person has given ear evidence. They are not the party, but they are a witness. They have only given ear evidence. In the ear evidence, some admissions come, sir.
Yes, Hearsay. Hearsay evidence?
In some admissions comes.
Yes.
Yeah.
Hearsay evidence cannot be accepted. No, that should be excluded from consideration. If by mistake hearsay evidence comes, court should not consider such evidence. Hearsay evidence should be excluded. It should not be allowed in the first instance. Even if it comes, it should be excluded from consideration. ಕೇಳ್ತಾ ಇಲ್ಲ.
ಅವರಿಗೆ ಕನ್ವೆ ಆಗಿದೆ ಸರ್. ನಾನು ನೆಕ್ಸ್ಟ್ ಪಾರ್ಟಿಸಿಪೆಂಟ್ ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಶ್ರೀಕಂಠೇಶ್ವರ್, ವೆರಿ ಕ್ವಿಕ್ಲಿ.
Sir, good evening, sir. Good evening, sir.
Yes, sir.
Hello.
Very good evening. Very good evening.
So my question is with regard to section 112 of Indian Evidence Act, about the legitimacy of the children, presumption.
Legitimacy.
Sir. Yeah, legitimacy. There is a presumption in favor of the wife. But when the Supreme
Not some.
There is a presumption in favor of the wife.
Hello?
Hello, sir. Am I audible, sir? So, my
Yes.
section 112, sir. There is a presumption.
Please, sir.
There is a presumption in favor of the wife, an adulterous wife, though she is adulterous, but she is protected under section 112 with regard to the illegitimate child. Now, my question, sir, with in view of section 497 of IPC being decriminalized, the society knows that illegitimacy can happen. But how to overcome this presumptive part of law, sir?
See, now Law Commission also has recommended for change of this law. The answer is that there must be change of law, that's all. Law should be changed. Suitably it should be amended. We should make a law, appropriate law, that's the thing. Otherwise this provision is there. Yes.
I'll be unmuting Mr. Ravi Hegde, sir. Mr. Ravi Hegde, quickly you can ask the question.
Yeah.
Sir,
am I audible?
Please, sir. Please, sir.
I am practicing in a trial court, civil court. My question is, apart from amendment, what is inserted now regarding presumption, can there be a presumption or conviction apart from the evidence?
And you are not audible. Kindly, what I would suggest is kindly send a question to the Q&A box. I'll repeat it, and our will be.
It's not clear. It's not audible. It's not audible.
There is some disturbance today, so I would read it out for you, sir. We will now take
Some disturbance.
The one offline question with respect to will, where the witness died, who to prove the will, the beneficiary is defendant. I repeat, with respect to will, where the witness died, who to prove the will, the beneficiary is defendant. This is a question.
Will? I am not getting the question at all, sir. I am not getting the question at all.
Am I not audible, sir?
No, not. There is no clarity in the. There is no clarity. I am not getting the question clearly. That's the.
How about now, sir? Am I audible now?
No. Shall I unmute?
No, please, sir. Am I audible now?
Yes.
Sir, the question
Yes.
with respect to will, where the witness
Yes.
who to prove the will, the beneficiary is defendant.
No, see, Evidence Act itself provides the mode where the witnesses have died, how to prove that signatures and other things. The Evidence Act provides for that. Where the witness is not available, Evidence Act provides how a registered document needs to be proved. That their signature must be proved by other modes. If witness is not available, you can't call them. You have to prove that it is their signature by other modes.
Right. Thank you. Mr. Sai has a question. How the burden of proof to be discharged in an offence punishable under section 400 of IPC? 400, section 400 of IPC. The burden, how the burden of proof to be discharged in an offence punishable under section 400 of IPC.
400. Just a minute. Penal code
Punishment for belonging to the gang of 400 of punishment for belonging to gang of the
any penal code. Indian penal code. See, 400 provides for punishment. Hello? Please. Sir, section 400 is a punishing section. The offence is under 397. Hello?
Correct. Absolutely.
That it is like any other, in any other criminal case, the evidence has to be adduced. That's all. The burden is on the prosecution to prove that. This is only a punishing section. The burden of proof will never change. The burden is always on the prosecution to establish the case beyond reasonable doubt. Then they... Yes.
Sir, I think there are two gadgets which are switched on. That is why I think they are facing that technical glitch. So could you please switch off the other gadget?
ಇನ್ಯಾವುದು ಎರಡು ಇದೆ ಓಪನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಇದೆಯಾ
ಬಹುಶಃ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ
ಈಗ ಇದನ್ನ
ಕೇಳಿಸ್ತಾ ಇದೆ
ಇದನ್ನ ನೋಡಿ ಸರಿ ಆಯ್ತಾ ಹೇಳಿ ನಾವು ಪ್ಲೀಸ್ ಸರ್
The last question for today is by Mr. K.R. Ashok Kumar. His question is, towards execution of pro note and consideration for the past transaction over several years, what is the presumption can be urged? I repeat it, sir, the question is very vague and broken. I repeat the question. Execution of pro note and considerations receipt for the past transaction over several years. What is the presumption that could be urged?
No, presumption of consideration is there. Now, for the money, if it is due, that is spelled out, it is all right. Presumption of the past transaction, promissory note is executed, isn't it? So there is no presumption here because consideration is already there, but it is of the past transaction. It's not where the man denies that money is not received, he admits the execution, then law presumes that consideration is moved. It is for him to rebut that and show that I have not received the consideration though the pro note is executed. Here there is consideration and also presumption that he has to establish that for the past transaction this document was executed. There consideration and there is also a pro note also. Yes.
Right, thank you. We will try
all the things are there. There is no.
Right, sir. We will try our luck with Mr. Gupta, sir. Sir, please unmute yourself and just try your luck.
Vikram, voice clear idea?
ಸರ್ ಸ್ವಲ್ಪ ಫೀವರ್ ಆಗಿದೆ, ಬಟ್ ದಯವಿಟ್ಟು ಕೇಳಿ, ನಾನು ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ಸಾಹೇಬ್ರಿಗೆ, ಕೇಳಿಸಿಲ್ಲ.
Okay. Sir, the suit for money, recovery of the suit money is a plaintiff is a financier. The defendant is a partnership firm. Several years, the finance transaction was being made between the plaintiff and the defendant firm. During certain transactions, the two partners left the partnership firm, retired from the partnership firm, and the retirement deed has been executed in favor of the partnership firm. Unfortunately, it has not been filed before the registrar of firms. Now the financier has filed a suit saying that you are also responsible for the recovery of the money.
Sir, it is a recovery suit, and the defendant is a partnership firm, and
Yes.
the partners have retired, and apparently that has not been filed before the concerned.
No, that should be. So then it is a the burden is on them now to show that they are retired in accordance with law, not that what they think that retirement. He says that registrar of firms, it is not there before them. If it is a registered firm, whether the retirement has occurred that way or not, they can plead and show to the court. If they show that they have retired from the firm, then there is no liability at all. If court says that no, your retirement cannot be accepted, or you are not retired as known to law, then liability can be, court can fix the liability.
Thank you, sir. I think because of the technical problem, we'll have to stop it here. Sir, my sincere gratitude to you for today's presentation, sir. Thank you so much on behalf of Advocates Association, Bengaluru.
Thank you, sir. Thank you all the members of the bar, all the elders. That was my parent association, sir. I am so glad to be with you this day, sir. I am extremely happy. Thank you all. See you sometime later. Namaste, namaste.
I would also like to thank Mr. Mallikarjun, advocate from Chitradurga, and Mr. Madhusudan, advocate from Hosadurga, who have helped us today. Thank you so much, sir. Sir, with your permission, now I will be signing off today's webinar.
Please, sir.